that you reverse. Thank you.
Thank you, Counsel. Last case on the docket today is LINDO Jolly versus State.
Good morning, Your Honors. My name is Michael Lambert. I represented the defendant at the trial level and I'm representing him here at the appellate level. May it please the court and please counsel. Mr. Jolly was arrested for a number of offenses. The charging affidavit, which resulted in the information being filed against him, is very specific. It alleges 5 separate events of using or accepting an EBT card for ineligible products. The dates of those acceptances was 1 in June of 2011, 2 in July of 2011, 1 in August of 2011, the last one on January 17th of 2012. The total amount of money that was obtained for those 5 separate incidents was $267.61. The state filed an information charging him with the offense to which he pled, the scheme to defraud, as a third-degree felony. That offense...
When he entered his plea, didn't he basically acknowledge that the amount could be between, was it $200 or $300 and up to $20,000?
No, the statute says that... Did he acknowledge that or not? Did he say that that was correct, that the figure could be between those two figures? Up to $20,000, I think it was. Well, you mean by entering the plea, he pled to what was charged?
Yeah, well, I mean, but did he acknowledge, in establishing a factual basis that it could be up to $20,000?
I don't believe so.
You don't think he did that?
No, I do not.
Okay.
I think the plea, it was a no contest plea. The statute says an aggregate amount not exceeding $20,000.
He did agree, though, that when he entered the plea, that restitution would be left up to the court.
Yes, just like if you say my guilt or innocence would be left up to a court. He wasn't stipulating that whatever the court finds, I'm going to accept. The state wanted initially $350,000. Then the state, the day of the sentencing hearing, was asking for $119,000. And then the judge came up with the $20,000 figure. I have yet to understand how they came up with the $119,000 figure. Obviously, the judge found $20,000, but the issue was the hearsay, the officer using a computer to say that it's a computer fraud detection system.
Wasn't there evidence from your client, separate from the computer program, which would have supported a $20,000 restitution? Didn't your client give some indication as to the number of transactions he did every day and the average amount of those transactions over some period of time?
He did not. If you look at the video, what the officer said to him was, how many people come in per day and use an EBT card? And he said, I think approximately 200. And he said, well, how many of those do you think would purchase ineligible items? And he said, perhaps approximately between 10 to 15. So the officer said, okay, 15. Then he said, well, what would be the highest level that anybody would make a purchase for ineligible products? And he said $50. So the officer then said, all right, 15 times 50 times 31 for the days of the month would then come to our figure. Well, that doesn't come to $119,000. That comes to, I think it comes to $167,000 if it was this 32-week time frame. If it were a 30-week time frame, it would have been $144,000. But no, Mr. Jolly never said, and the officer admitted, that he never even provided him with a list and asked him, is this accurate? And that's why the video was so important, but the judge didn't want to look at it. But in the video, I mean, Mr. Jolly, he is of Indian descent, is nodding constantly throughout the recording. He never says, I took from 15 people ineligible purchases for products at $50 per person for 31 days of every month.
He also never said, I didn't do that. I mean, he knows
No.
the difference between yes and no.
Oh, yeah, right.
So-
But he wasn't, simply because he didn't say no, he wasn't accepting it. And again,
By his own testimony, it was 10 a day. You said 10 to 15. Even if you use the 10, you're going to get to the 20,000, right?
well, he said approximately.
Well, but you're going to get way past the 20,000 even with the 10, right?
Well, you could, but he would, again, if you look at the charging affidavit, and if you look at the pre-sentence investigation report, the only thing that's in all of those are these 5 separate incidents, and they're outlined. There's nothing in the police...
I see that as a different issue, whether or not you can limit you have to limit the restitution because of what was specifically contained in the information.
Okay.
But as a separate issue of, was there enough evidence before the court to justify the $20,000, I don't see how you have to get to the computer data or the computer testimony to get to that number, that there was enough said by him, even if you use the lower end or his numbers, that you're going to get beyond 20,000.
I think there's a difference between if you're going to get to that figure because of what the agent said, or if you're going to try and get to that figure based upon looking at the video. If you look at the video...
Here's what he said, and goes back to my prior question. My notes indicate that when he entered his plea, he acknowledged that between June 8th, 2011 and January 7th, 2012, he permitted customers at the convenience store which he worked to make purchases with their EBT cards that he knew were unauthorized. The items included cigarettes, beer, candy, cookies, chips, and phone cards, and he further acknowledged that the amount of his convenience store profit was between $300 and $20,000. And he further acknowledged that he was going to have to make restitution, and that the restitution amount would be up to the court. So basically, he acknowledged that the restitution could be somewhere between $300,000 and $20,000, didn't he, when he entered his plea?
That way, but he wasn't saying that I took $20,000.
He said the range could be between $300,000 and $20,000, right?
If there was evidence to support it.
Well, I mean, he said, he didn't say if there was evidence to support it. He acknowledged when he entered his plea that the amount his convenience store profited was between $300,000 and $20,000 from this illegal activity. And he said that at his plea, didn't he?
In the written plea, yes, that's contained in there. And
then the agent also testified about a statement that he made, when he was questioned, about the number of transactions and how much the transactions were per day, and there was a figure of $22,000 mentioned, right?
Yes.
All right. And you're saying that's not enough to establish?
And I apologize for interrupting.
Go ahead.
He didn't make a statement that I took $22,000 every month in illegal purchases.
I think the agent was testifying as to his statement, what he was telling the agent, and then the agent kind of calculated it out, right?
Right, but that's not what Mr. Jolly said in the recording.
Well, he told the agent during his statement to the police that, there was something like 15 transactions a day, each one something like $50 and that sort of thing.
No,
He didn't say that?
No, sir.
Let me go back.
What he said was that the agent asked him, now in the record, you're going to see the agent saying that that's what he said.
That's what I'm saying. The agent testified as to what his statement was, and the agent testified that he said in his statement, what I just reiterated to you, isn't that right?
Yes, sir, that's what the agent said, but the agent also said that my recollection is simply a deduction of what I think he said. It's not accurate. An accurate reflection of what he said will be the recording, and I introduced the recording. And in the recording, that's not what was said. What was said was, the agent asked him, how many people come in using EBT cards? And he said, about 200. He said, how many of those do you think might make ineligible purchases? He said, approximately 10 to 15. Then the agent said, what would be the highest of any ineligible purchase? And he said $50. Well, then the agent took that.
And the 50, he calculated it.
Even if you take his lowest number, 10, and spread it over the 9 months we're talking about here, that's like 2,700 transactions, so it would only have to average about $7 to cover the 20,000. Are you saying there's not sufficient evidence to say that? If they're buying beer and cigarettes, can we not presume that if some of the charges are as much as $50, that an average of $7 is not an unreasonable finding by the trial court?
Well, I mean, if we're going to do everything on averages, then probably it's not an improper averaging, but I don't think it's on averages. I mean, the agent even said, when I asked him, I said, is the only evidence that we have of proof of concrete restitution, something obtained, the $267.61? And he said, yes. Everything else is based upon conjecture, his computer, and then this discussion that he had with Mr. Jolly.
Mr. Jolly, in his interview with the detective, does acknowledge correctly that, and I'm saying correctly for you, not
Yes, ma'am.
that he acknowledged correctly, but that he acknowledged that to his knowledge, he was the only one allowing these improper EBT transactions.
He did say that.
Okay, so whatever we have, we can attribute to at least him.
Yes, I think he kind of fell on a sword.
All right.
And I would like to reserve anything.
Got about 4 minutes left.
Thank you, thank you.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. If this court doesn't have any questions, I'm going to rely on my brief. I believe that the state presented more than sufficient evidence to show the amount of restitution that the judge imposed in this case. And
What about your preservation argument? You indicated that basically all they objected to was the fact that it was hearsay and they didn't have the documents that were generated by the computer. And you say that that's not sufficient to preserve the issue as to whether they had the right to cross-examine the computer.
well, he's raised a Crawford issue. They didn't make a Crawford objection. They made just a basic hearsay objection.
Right.
So no, the Crawford argument isn't preserved for appellate review. And additionally, that part of the testimony, if you look at it, when they talk about the averages, the national average, and the state average per store was, the agent was testifying was $3,000, he's already pled to this crime. He's already pled to an organized scheme to defraud. The time to challenge that was before he pled. That had nothing to do with the amount of restitution. The amount of restitution was based on the defendant's statements that he gave, which were that between 10 and 15 transactions per day, upwards of $50. That's what the restitution amount is based on.
Were the allegations of the information limited to the 5 specific transactions?
Absolutely not. Those 5 transactions, that was part of the investigation, as was the computer reports that tagged that showed that store was making having $30,000 worth of EBT purchases made in a day, or not a day. And the average was $3,000. That's the other tag. That's what began the investigation. But there's nothing in the information that limits it to those 5 transactions with the confidential informant.
And he pled to count 3, correct?
Correct. He pled to all 3, but at the beginning of the sentencing hearing, they...
Subsumed in...
Yes, yes. So if there are no further questions, I'd ask that you affirm. Thank you.
Did you address the preservation issue as to whether you even preserve... You're not arguing fundamental error here, I don't think. You're
No,
just
sir.
Did you even preserve this issue for review if the only objection you made was hearsay, you didn't have the documents generated by the computer?
Well, in going back and looking at that, I think that was probably an improper way to raise it with regard to the confrontation. However, it just being two issues. The hearsay, one that the agent was talking about, a printout that he had from a computer that generated, that likely deemed fraudulent ineligible purchases, but secondly, that had never been provided to the defense. And again, that's why I would go back to the charging affidavit is very specific. If you look at it, it's in the record. There is nothing that talks about this going on for more than these 5 times. There's nothing about...
Well, actually, it pled to count 3, which is the organized scheme to defraud.
Yes,
and I
ma'am.
have the information up here, and it reads in count 3, in that Lindo P. Jolly, on or between June 8, 2011 and January 17, 2012, the County of Volusia did engage in a scheme constituting a systematic, ongoing course of conduct with intent to defraud one or more persons or to obtain property from one or more persons by false or fraudulent representations or promises, and did obtain property of a value more than $300 but less than $20,000 from one or more such persons, contrary to Florida statute. So there's nothing in that particular charge that he entered a plea to that would limit it to the transactions that were done by the undercover people that went in.
Other than the verbiage of the information, the first controlled purchase was June 8, 2011. The last controlled purchase was January 17, 2012.
Right, but on it, but it's alleged that on intervening days in between, on or between.
Right, and I agree. And
Inherently, it had to cover other transactions since it was a minimum of 300, and those 5 transactions didn't even come up to 300.
if you look at the statute doesn't require a minimum of 300.
I understand, but the allegation of the information was that he had transactions in excess of $300, which would be directly contradictory to your argument that all it covered were the 5 specifically identified transactions earlier in the information, right? Because that would be inconsistent.
I don't agree that it contradicts my argument, but I would say on paper, it said $300 or more, but less than $20,000.
But if your position is that count only covers the specific transactions which were previously identified, those don't even total up to $300.
Well, no,
obviously, that allegation couldn't have been limited to those 5 specifically identified transactions.
But if it did deal with what the agent says occurred, the charge would have been $50,000 or more, which is a first-degree felony, same statute. So it's clear that...
Be thankful for small favors.
That's, a plea was entered.
Thank you, counsel.
Thank you.
We'll be in recess.